welcome. I am your host, Daniel, and welcome to the show. Today is the Ninth Circuit Court, which is something different. Um, and just a reminder, if you like this content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to the channel and help the channel grow. You can join me on Rumble if you want to join me on Rumble. That helps out too. All right, everybody, let's get into the Ninth Circuit Court. All right, let me fix this.
Here, my name is Arden Hubbard. I'll be your court deputy today. If you have any questions at all, please feel free to let me know. I'm here to help. Today on our panel, we have presiding Judge Miller, who will sit in the center. Judge Miller's right will be Judge Smith, who you've just met, and to Judge Miller's left will be Judge Johnstone. Once you get up to the podium, please ensure that you're speaking clearly into these microphones. On the podium as well, you'll see the clock. It displays your full time, including your sum up and your rebuttal time. If you would like to reserve any time for rebuttal, go ahead and announce that to the panel, and I'll set the clock on my end so that once you start to run into that rebuttal time, the clock will turn from green to yellow. As the clock turns from yellow to red, you will have officially run out of time and the clock will start to count up, so try to wrap up your arguments from them. Please silence your cell phones, and no courtroom photography is allowed until after the session is concluded. No recordings are permitted, but we do have recordings of our live stream available on our website. If you need any help locating those, go ahead and let me know after the session and I'll help you find them. Thank you so much. All rise. The United States Court of Appeals for the Ninth Circuit is now in session.
Good morning and welcome to the Ninth Circuit. We'll hear argument first this morning in Hai Hong He against Todd Blanche. Counsel, you may proceed.
Good morning, Your Honors. I'd like to reserve 2 minutes for rebuttal.
Okay, you may, but just keep an eye on the time.
All right. So there are two main issues in this case where the IJ first the IJ found that the petitioner Hai Hong He didn't mention that she was groped. But on her I-589 she mentioned on AR-536 that she was harassed as well as monitored by the police and supervised.
Well, let's look at the facts. It's my understanding that she was only into this problem because of religious prosecution, right?
Yes.
And the first time, with the first incident, there was a male police officer who interrogated her the day before she came into the room. And then he started to get close to her and started to take her clothes off and was feeling her breasts and her private parts. Is that correct?
Yes, Your Honor.
So that, in fact, given what that sounds like sexual assault, right?
Yes, that is the first instance which was in her.
Yeah, that's the first incident. And the second incident, the same police officer, again, touched her body parts with his hands. And since there were other government officials in the room, he didn't do much more than that. That's her statement, right?
Yes, Your Honor.
And that's also sexual assault, isn't it?
Yes, but it could also be characterized.
Isn't it sexual assault?
It could be characterized as a sexual assault or sexual harassment. I think.
So it wasn't necessarily wrong for the IJ and the BIA to suggest that they were sexual assaults, right?
Yes, but the question.
And didn't your client also have the job of, in an application suggesting, have you, your family, or close friends or colleagues ever experienced harm or mistreatment or threat in the past by anyone? And she did not list the second incident. Isn't that true?
Your Honor, she listed.
Is it true that she didn't list the second incident?
She listed the second incident as a harassment in her I-589 on her I-589.
The affidavit only says one assault
Yes.
by the police officer at the police station. Never mentions any other touching that when she reported the police station every week, right? Isn't that true?
She mentioned that she was.
Is it true that that's what she did?
It's true
I mean, all I'm trying to do is say, here we got this evidence, the IJ had it, the BIA had it, and now I have it. And it seems to me that based on what I've laid out here, there's no way I can say substantial evidence doesn't sustain what the BIA and the IJ did.
Your Honor, the I-5.
Well, let's talk about the explanation. What did your client say to explain?
She said that she was told not to write a.
She said an assistant in her former lawyer's office told her not to list too many details.
Mm-hmm.
Come on. Would your office tell her not to list these details?
No, Your Honor, but my office will also not have a.
I know your office wouldn't, but the thing that bothers me about this is I'm looking now for substantial evidence. And it seems to me that her explanation was just outlandish, given what she's got to say and why it's going to help her.
Mr. Lee, does your client has a religious persecution claim,
Yes.
not a sex-based persecution claim. Do the sexual assault or harassment incidents go to the heart of that claim, and should that matter?
No, they do not. The core of the claim is that she was not permitted to practice her religion because when she did, by going to house churches, she was arrested, detained, harmed in various ways, beaten.
Well, why shouldn't this inconsistency at least serve as substantial evidence for an adverse credibility determination?
First, there's a case in this circuit, Parasami, which in similar circumstances showed that when an incident of sexual assault was brought up at the hearing, it did not go against the petitioner. It did not go against petitioner's credibility because delayed reporting of sexual assault is very normal, as the court found in that.
But isn't it true that Alum says that the claim need not go to the heart of the claim? That what we're really looking at is what is happening and whether it was, in fact, a lie, that she didn't do it the first time? And then we look at what else there is, even though, and she didn't go in here because she was going after a sexual claim. She only went to the police station because it was religious persecution. It was part of a religious persecution claim, right?
Yes, but that's just the omission that doesn't go to the heart of the claim, not a inconsistency that does.
Well, but just a minute. It doesn't need to go to the heart of the claim. You'll agree with that, right?
It does not, but also there's
Alum says it doesn't need to, right?
yes, Your Honor.
And then let's go to the next one. Let's talk about her change of address. She was told that she reported her address in Honolulu. She knew she had to report this new address. She knew she couldn't change her address without the permission of the officers. She was only released on her own recognizance because she would give them the change of address. And then she admits she went to Hawaii, Maui, and started paying rent. And she did not tell anybody.
Your Honor, she did tell the immigration officers of her change in address and
Well, she told them about Kona, but Maui, she didn't tell anybody.
and the EOIR 33 instructions say that you must file this form with the immigration court with the change of your contact information or receipt of a charging document with incorrect contact information.
So you're saying that all she had to do is give an address any place as long as she could fly back immediately and get there?
Your Honor, I'm
Was
saying
that
that
what
she
the
was,
judge asked her to
she was
do?
receiving the court documents as required, and thus her lack of filing a EOR 33C shouldn't go to her credibility. It's
Well,
just a technical issue.
I'm certainly not an IJ, and I'm certainly not the one who gave her that responsibility. But I remember being on the district court and having probationers who I wouldn't let out of jail unless they told me what their address was, and unless they told me when they were going to move and what they were going to do. And if they didn't, they went back to jail. And this is the same circumstance. And this lady didn't tell. She just went to Maui and thought, well, I'll fly back when I need to. Now, that isn't what the judge asked her to do, is it? Doesn't that go to her credibility?
I don't think it does, Your Honor, because it's just a technical issue, and the instructions
Technical.
for the EOIR make her actions legitimate, Your Honor. She was in contact with the court, and the the court was she was receiving all the documents that she needed to, and she was going to the immigration court at the time. She did not miss a hearing.
Is there any evidence that she was attempting to deceive the IJ or anyone else?
No,
about
there
where she
is
was?
no evidence, and in fact, the IJ also found that nothing in her demeanor detracted from her credibility. So, Alam, Your Honor mentioned Alam, but Alam also says that you have to look at the totality of the case, which includes not cherry picking only facts that go towards an adverse credibility determination under Shrestha.
All right, we've used up most of your time, but we'll give you 2 minutes for rebuttal.
All right. Thank you, Your Honor.
May it please the court, Your Honors, Joanna Watson on behalf of the government. Looking at the totality of the circumstances here, which is what we do, you discussed all the record does not compel reversal of the agency's adverse credibility determination. I mean, it was a glaring omission in the asylum application and in her statement that she had.
But why was it glaring? I mean, this is not a claim about sex-based persecution. It's a claim about religious persecution, right? And the gravamen of the persecution theory is that she was arrested and told, like, you have to stop going to this church. Like, that's the core of the religious persecution claim, and that this has nothing to do with that, does it?
It absolutely does. I mean, this case turns on the lack of credibility of petitioner.
Okay, but I mean,
Ultimately-
that's question begging, right? Because you're saying she's not credible because this omission, like, is really important, and the question is, like, what does the omission have to do with the religious persecution theory?
Because you have to, in order to meet her burden of proof for asylum, she has to show that the harm that she experienced rose to the level of persecution. And while that was not at issue here, her credibility was. I mean, it's a glaring omission, and it bolsters her claim when she gets into.
But I guess the point of my question, which I think you still haven't answered, is why does she doesn't need this to establish a religious persecution claim, and I'm not sure how it really moves the needle at all on religious persecution. Like, the theory of persecution is, you're arrested and told, like, you can't go to the church you're worshiping at anymore, right? Isn't that sufficient to establish persecution?
Not in and of itself.
Ms. Watson, where does she rely on the second assault for her claim?
She did. She raised it for the first time before the immigration judge during the hearing.
Well, I think in terms of the theory of her persecution, so it came up during the hearing, right? When, of course, we're also trying to establish credibility, but not in the affidavit, declaration, application. It doesn't seem to, nothing on the merits in the briefing here seems to turn on it. So just that it came up during the hearing.
Correct. It was omitted from her asylum application and in her statement. I mean, these are significant details, like I said, that would go to, because persecution is this extreme concept that requires, more than just being.
So it's the government's position then that, but it seems like that would be the second assault that in terms of her relying on it, in order to establish a religious persecution claim, that the second assault would be essential to determining nexus on the basis of religion. I mean, it just doesn't seem, as Judge Miller says, that it's any part of any of that.
Under the totality of the circumstances, under post-real ID cases that we have here, you can rely on anything. It doesn't all have to go to the heart of the claim, but this goes to the heart of the claim that she was.
So it doesn't matter that whether it goes to the heart of the claim. Your backup
Correct.
is that, okay, now this is in the mix under Real ID, so it's part of the totality.
Exactly. And
So then it's just an omission of this encounter following a
Correct.
second encounter.
And it's pretty significant because it bolsters her claim of that she was persecuted by leaving out a second
Well,
sentence.
that takes us back to, to whether it's actually, it's the government who's claiming that it's the heart of the claim. If it isn't, then it's just part of the totality.
Correct.
But in this claim, isn't it so that he must show that she was religiously persecuted? And in order to show that, she's got to have credible testimony about that religious persecution. And the IJ is trying to determine if it's credible. And therefore, the IJ, looking at what she did in pursuit of her religious persecution claim, finds she wasn't credible in saying the things that she said. So therefore, it seems to go right at whether she was persecuted or not. Because if she can't show she's credible, how can one believe the rest of her story? Isn't that the way it happens?
That's exactly the way it happens. And then when you look at the other factors here,
Okay, but can you address our decision in Lie, which I read to say that, omissions are less probative of credibility than actual inconsistencies, and that, we said the mere omission of details is not a sufficient basis for an adverse credibility finding. So how do you account for that?
we're looking at the totality of the circumstances here. And I mean, and this does go to the heart of her claim. I mean, that.
Okay, well,
she was
now,
persecuted.
okay, now we're.
Right, we're going back to that. And if you look at the other factors too, with the not updating her address and the really conspicuous timeline of events here.
On the address, do you agree with your friend that it was a request for contact information or that she was asked for her current residence?
I mean, she has a duty to update with her current residence. I mean, for notifications from the court. And then
Well,
there's a duty
those are two different things, right? For if
with DHS.
Right. So if it's her view that notifications to the court, that she'll get them at this contact information and she might be residing someplace else temporarily or coming back, why is that false?
Well, she was several months and, she had the privilege of being released on her own recognizance, and then she doesn't.
And so the request was for her, you disagree then to my question, it wasn't for contact information, it was a request for her residence and she gave an address that she was not residing in?
Yes, she didn't provide the updated address of where she was for several months at a time.
Well, and isn't it so that it isn't a matter of her just changing her address? She admits she lived at a different place. She admits she paid rent at a different place. She admits she was at a different place than what she was supposed to have told the judge where she lived, right?
Correct.
And so I guess I can see how all of that shows a lack of diligence, or perhaps a lack of respect for the authority of the court to impose rules that she has to follow. But how does it show a lack of honesty?
We're looking at totality.
Well,
All of these different.
okay, but I
factors.
mean that is true. But how does this contribute in any way to the totality?
That she wasn't candid, the immigration court, of her current address. I mean, and she admitted that she was.
But she didn't lie about it. She just failed to comply with the obligation.
Which she had a duty to do.
Right. And so I think the question I asked was, that shows a lack of diligence and a lack of respect for the authority of the court to impose rules that she has to follow. But how does it show a lack of honesty? It's not dishonest to just not do the stuff you're supposed to do, right? It's bad. People should do the things that they're supposed to do. But it's a different kind of problem from dishonesty.
It might not be the most relevant of the factors that are being considered. But then when you look at the other factors too, and here, Ming Dai, the court's job is not to see if it's possible to reach another conclusion. The court's job is to see if the record compels a different conclusion, because subjective minds can differ.
On that, Ms. Watson, what's with respect to to get to the heart of the claim. So the actual asylum case, as I take the record, his testimony, her grandmother's note about the arrest, the father's note, all aligned with the country conditions report in terms of the actual religious persecution claim at issue here. Where is the record support for the implausibility finding, the IJ's finding that the board adopts that that's just implausible?
Well, and again, going back to the totality of the circumstances, and you look at,
Well, the totality is the totality, but you also can't cherry pick. And so we have here, the only thing, and let me know if I'm wrong, but the only thing that the agency attacks as to the substance of the claim, and I get we're looking at the totality, but you can't cherry pick, is just that it's implausible, where we have three different sources all lining up as to the actual religious persecution that she claims to have suffered. Why is where in the record should we look to find that that's implausible?
well, I mean, you can, limited weight was provided to these documents. The immigration judge gave limited weight to these documents because they were not originals. Nobody was there available for cross-examination. And some of the documents kind of contradicted almost, or didn't have any of the details that she mentioned as part of her claim.
The arrest, the
And-
beating, the threats, it being labeled a cult, all of those things seem to line up.
Well, I mean, the notice that was sent to her says it was handed directly to her from the
I'm not, I don't
the
think any of us are experts on the Chinese equivalent to Rule 4 of the Rules of Civil Procedure, but I think there could be different pieces there. I'm talking about the substance of it, what the basis of the implausibility reading is to the fact that she was beaten.
such a small church. It was elderly ladies, and the fact that she was going once a month for the short period of time that they would come after her at school.
And is there anything in
Her
the,
grandmother would turn her in.
is there anything in the country conditions report or otherwise
There are.
to show, if I can finish the question, to show that the Chinese government is less inclined to persecute churches where the parishioners are elderly?
Well, it talks about, they're more inclined to go over churches that are much, much larger as opposed to these very small churches.
I see, but there also, in the country conditions report from the report from 2017, there were a number of reports described about authorities harassing and beating people in small churches as well.
And it also discusses, I believe there's 70 million Christians living in the country, and there are sanctioned churches.
Okay, but this was not one of them, was it?
It appears not.
Okay, so what is the relevance of?
If she was found credible, but she's not found credible as to her past persecution claim.
Right, but part of the reason that she wasn't found credible was because of the supposed implausibility.
Right.
So the basis for the implausibility has to be something other than her lack of credibility.
I see what you're saying. And I'd get back to totality again, and there's other factors in here besides the implausibility,
Okay. All right.
which was the timeline of events here that line up where she's attending boarding school from until 2015, but in January of 2015, but she obtains a passport in September.
And I think the agency's basis for that unplausibility finding is that she was coming here for economic reasons, she's an economic refugee, and the record support for that is?
The fact that she never went to school and she got a visa to go to school and she's just worked, even though she had talked about the reason that she had gotten her passport, it was because her grades were good and she was considering coming here in September. And then it's November 2014 is where she's purportedly arrested at the house church. And then January, she obtains the visa and comes here. But you look at this timeline, it's a bit conspicuous on top to the omissions. And then the corroboration, the evidence, how it wasn't able to corroborate. I mean, she has a medical report. She talked about having all these injuries, and she had an IV, and the medical report doesn't talk about any details or any kind of, except that she had like bruises. It doesn't go into details. And we talked about the village committee notice. And ultimately, when you look at all of these factors, it doesn't compel reversal of the agency's adverse credibility. I think I'm going over her.
Yeah, I think we have your argument. Thank you.
Thank you.
Your Honor, so I found the judge's instructions to her on AR 130, which is if you ever change your address, fill in a blue form and mail it to a court in 5 business days. She didn't say if you ever change your residential address, and she didn't say this was because of her bond. She just said if you ever change your address, mail in a form. So she didn't change her mailing address. She didn't mail in a form. That might not be the way everybody would understand it, but I think it's a reasonable understanding for her to make.
It's a reasonable understanding if you want to put the gloss on it that you want to put on it. But the bottom line is that those who were in charge of the claim and looking at it said, number one, we don't think she's credible for what she's done based on her applications, and we're looking for other things which might add to that. And when we look at what other things which we might add to that, she was told she was supposed to do that and she didn't, so she was being false about it, that she was not being credible about it. That's the way they looked at it. And I appreciate that I could see it different, but this is substantial evidence review, isn't it?
Yes, Your Honor.
And so all I've got to find is some evidence to sustain what the IJ and BIA did, right?
Yes, but
We've also said a lot here just recently about the affidavits and letters that were provided from interesting parties. The father, the Botetti's widow, an acquaintance. But we know there's a case called, and this is an Idaho problem, Mukulumbutu, whatever that's not the way it's not the way it is, but that's the way I see it, where we said right there, the BIA did not err in concluding that the evidence that the petitioner provided was entitled to limited weight because the affidavit and letters provided were from interested parties. That's what we have here, interested parties. So again, the IJ and the BIA are not wrong to give all that limited weight, are they?
the IJ and BIA were speculating about.
Well, but all they did was say, we're not going to give it weight because it's all interested parties and they've never been cross-examined. And now I'm supposed to, on a substantial evidence review, say, you're wrong. Substantial evidence?
Yes, but the core of the IJ's issue is apparently a speculation about how the Chinese government would provide her a notice, how the Chinese hospital would provide medical reports, and there's no record evidence or testimony about a Chinese civil procedure that would allow her to make these determinations that this is how these things work. And that's the same thing about the EOR 33. There's evidence that there's no evidence that she was deliberately not following instructions when even the instructions for a form say if you when you have to fill it out is fill this form out with the immigration court within 5 working days of a change to your contact information or a receipted document with incorrect contact information. So this is all just her speculating about the petitioner, about Chinese government's motivations and how they do things.
Right. Thank you very much, Mr. Lee, Ms. Watson. The case is submitted.
Your Honor.
And we'll hear argument next in Gong against Blanche. Mr. Lee.
Good morning, Your Honors. May the police court. My name is Jixian Li, and I represent the petitioner. The BIA in its decision states, we agree with the immigration judge's decision that incidents experienced by petitioner and her immediate family, even when considered cumulatively, do not constitute past persecution. The BIA then cited page 7 and page 8 of the IJ's decision. I have the page 7 and page 8 of IJ's decision in my hand. I read both pages line by line, word by word, again and again. I just could not tell where did the IJ consider the cumulative effects of all the incidents that are experienced by petitioner and her immediate relative. As a matter of fact, the immigrant judge found no past persecution because of a lack of credibility. For instance, this is the IJ's decision. It says, respondent, that means petitioner here, respondent assigned a statement about her daughter being kept from classes in August 2014 is not to be believed. So therefore, the IJ did not consider the fact that the petitioner's daughter being kept from school in determining whether or not that event considered along with other factors would rise to a level of persecution. But IJ simply said there's no past persecution here because petitioner is not to be believed.
So the board may have been wrong in its characterization of what the IJ said, but don't we still have a conclusion by the board? I mean, the board is expressing its own opinion that the incidents experienced by the respondent, even when considered cumulatively, do not constitute past persecution. And so isn't that a factual determination by the board that we have to review for substantial evidence?
What exactly the board says, Your Honor, what the board says, we agree with the IJ's conclusion. So the board did not reach the conclusion.
Well, I mean, if you say, I agree with someone else's conclusion that, whatever. I mean, there's really two propositions embedded in that statement. One is, the other person reached this conclusion, and two is, I am reaching this conclusion. And in this context, the first part of that might have been wrong. I mean, I take your point about the IJ not having really quite said that, but I have trouble reading the sentence as anything other than like the board is expressing its view of this proposition that the harm doesn't constitute past persecution.
And then we look at the BIA's decision itself, and the reason why BIA did not believe there's a past persecution here, the BIA only said that there's no said two things. One, that experienced there's no the prisoner did not experience any family planning procedure, other family planning procedure, and also secondly that there's a economic harm. The economical harm that she experienced is insufficient to rise to the level of.
Let me stop you just a minute. Is there any part of her persecution that the board did not address?
Yes, Your Honor.
What?
For example, that the physical harm petitioner suffered when she resisting the abortion, and she was.
I mean, it seems to me, if I read the paragraph on page, it's at the record AR 43, and I look at the AR 96, and I look at all the things that the BIA looked at, that they're looking at all of the evidence that you say they didn't look at. I mean, I'm trying to figure out what you say they didn't look at that they should have, that we therefore should then say there's not substantial evidence to sustain what you did.
Okay. Yeah, first, as I just mentioned, that the petitioner testified that she was slapped so hard that the corner of her mouth was bleeding.
Mr. Lee, on that piece, so the board cites the transcript, and then the transcript, I think at AR 135, the pages that they cite, Ms. Gong says, after I gave birth to my second child, the family planning office fined me. I was forced to have an IUD insertion. While I was pregnant with my third child, I was caught by the family planning office and they requested having an abortion, and I was also beaten up. Does that suggest then that the agency did consider the severe slap?
Yeah, the BIA cited that portion of the administrative record when the BIA was discussing the IGS conclusion. If we look at the IGS decision, the IGS did not cite to that transcript. So therefore, if we read the
Okay, so I guess circling back to Judge Miller's question, if the board, we're reviewing the board's decision. If the board considers the evidence and the IJ, it's not clear whether the IJ did, why is that a basis to grant the petition?
and also and also the transcript that Your Honor just referred to did not say anything about the denial of the social benefits to petitioner's daughter and the denial of educational opportunity. And also that portion of the transcript did not say anything about the repeated and specific threats made against petitioner after she fled the country. And also the IUD insertion and the health impact of the IUD, that was not considered either. So,
well, I guess in terms of understanding, I understand your claim to be one of the cumulative consideration. And so it may not be that the agency considered every action, but considered if it considered the most important ones. I think you highlight the assaults on the petitioner at the clinic as being probably the most probative one. If it did consider that, what are we left with if it doesn't consider these remaining pieces? Can we take it to be saying that it doesn't cumulatively amount to past persecution?
well, the standard review is that a given set look at a given set of undisputed facts to see whether that rises to the level of past persecution. Now we have two different sets of undisputed facts. One set is what we envisioned about the BIA in its decision, which excluded the IUD insertion and then the denial of the educational opportunity for the child. So, and the BIA actually did not make a decision based on that set of the facts that is in record.
But it cites to the part of the transcript where all of that is testified to. Setting aside the educational opportunities, it testified to the IUD, the fine, and the being beaten up.
Yeah, actually,
If we get past persecution and we go to future persecution, did Gong offer any evidence at all that she would be subject to sterilization if she returned to China?
oh yes, Your Honor.
What?
And
I didn't find any.
no, she testified actually the family planning officials went to her house and to talk to her parents-in-law and trying to pressure her to pressure her from returning to China for tubal ligation. And this, I have the,
That's the best evidence you have of that?
yes, Your Honor. And then,
Okay. You've answered my question then.
Yeah, and I see we've
okay.
used up just about all your time, but we'll give you 2 minutes for rebuttal.
May it please the court, Joanna Watson, again on behalf of the government. Looking at substantial evidence supports the agency's determination that the harm that petitioner experienced did not rise to the level of persecution. While it's far from ideal what happened, after the birth of her second child, she was required to have an IUD inserted, but there's no indication that it was forcibly done. Like I believe Lee's one of the cases that talks about rising to the level of past persecution, where 2 nurses held the woman down and forcefully examined her to see if she was pregnant, things like that. In this case, we don't. Pardon me.
I'm trying to figure out the difference between being required to have it done with the understanding that there's maybe an implicit threat of it being forced to do and having it being forced upon you.
She uses different terminology. You'll see throughout, saying that she was required. None of them suggest that it was forcefully done. And then after the birth of her second child, while she was fined, she conceded before the board that fine was 58,000 RMB didn't rise to the level of persecution. They were able to pay the fine. They started businesses. So that's after the birth of the second child. And then with the third child, while, it's far from ideal that she was taken in by family planning and she, refused to sign off on aborting her child. And during that incident, she was slapped and not ideal circumstances, but they let her go. And she was able to, she went into hiding went to Switzerland for a little bit and then into hiding and made it to the United States and was able to birth a healthy child. And all of these things adding up together don't come to rise to the level of past persecution. And ultimately, there's no well-founded fear here. Because, if you have past persecution, there's a presumption, but then the government can, but here we have no past persecution. But in 2016, these policies changed and they allow for 2 and sometimes 3 children. And there's evidence in the record that while her US citizen born child, I believe is around 11 years old now, she may have to pay for education if she doesn't decide to, because she's a US citizen, she wouldn't be able to get the benefits in China, but she could if she went with her Chinese citizenship, but they'd still be able to go to private school. And her other 2 children are adults now in their 20s and going to college. And she's almost 50 years old. So the likelihood that she would be required to have a sterilization, it's highly unlikely. And nothing has happened to her husband.
Is that a finding the board made, the point about her age and how it interacts with the Chinese policy?
Not necessarily. I was not trying to do a Chenery violation here or anything, but I understand what you're saying. But I just wanted to put that out there because if you look in the record before the board, I have the site right now. She talks about at the time she was pregnant with her third child. She was 37 years old, and how she, absolutely didn't want to abort because it might be the last time she'd be able to have another child. So it seems like in this case, it would be highly unlikely that she.
I appreciate your involvement in the issue you're now talking about, but it seemed to me the essence of petitioner's appeal here is that the BIA ignored important evidence in support of the asylum application. That's why I asked him about it, and that's why I'm now turning to you.
Okay.
The petitioner says the BIA erred because it ignored the physical harm Gong suffered ignored credible threats made against Gong, and failed to take into account the threats and harms to Gong's children. And he says that 2 and 3 times. Where in the BIA decision can you see that what petitioner is arguing here is false?
Well, the board here, in talking about after the birth of her
I
son.
mean, I want you to look right at what the board did and tell me, how did they take into account the physical harm Gong suffered?
I can tell you that. On page 2 of the board decision AR4, the board talks about after the birth of her second child, she's forced to submit to birth control. Excuse me. And it cites
That's
to the
on
IJ.
page 2?
Right. And the board cites to the IJ at 3. And the IJ at 3 is exactly where the immigration judge, in summarizing the testimony and everything that happened in this case, talks about how she was they tried to force her to sign a consent for abortion, and talks about how she refused the fingerprints.
Where do they?
AR 91, I'm referring. The board references the immigration judge's decision on page 3, which is AR 91.
I've got it.
And on that page, the second to last, or the last full paragraph, discusses the harm, all of the harm that happened to her.
But we're talking about specific harms. First, the physical harm Gong suffered, and I appreciate where he went. The next was the credible threats made against Gong. Where do they talk about those?
Well, the immigration judge.
We're not talking the immigration judge. We're talking the BIA decision here.
It cites to the transcript where she talks about what happened to her. I mean, all of those transcript citations refer to everything that happened. The fines that she had, the IUD insertion, everything
Where does
that
it
happened
discuss
to her.
the threats to the children?
Where did they discuss the threats and harms to Gong's children was my next question.
Well, there wasn't threats to the children. I mean, when her son was born, she
The
was
denial of
required-
benefits, I think, is.
Right, and she conceded that she paid the fine, and then her son was able to have access to all the benefits. I mean, and she conceded that that fine didn't rise to the level of persecution before the board.
Okay, I'm glad to have your answer.
Okay, and there's no further questions. I would ask the court to uphold the agency's determination that there's no past persecution, and that the well-founded fear there is no well-founded fear now that the population control policy has changed.
Thank you very much.
Thank you.
Rebuttal?
I just want to address the future persecution part. In this case, the BIA actually found there's no well-founded fear of persecution because that her fear of going back is objectively unreasonable. And for the BIA to reach that conclusion, the BIA relied exclusively on the channel country background information, the report. And the report supports respondents' claim that she would face, based on the record at the time, that she would face tubal ligation because she clearly testified that the family officials went to her house and to talk to her parents and trying to get her back to China for tubal ligation. And also to achieve that goal, they did not allow her daughter to go to school. So, and also the country report, this page 223 of the administration record, it clearly says that the Chinese government is still relying on forced abortion to implement is now two-child policy. And in this case, Your Honor, that the petitioner has 3 children. So therefore, clearly that she has at least based on country condition that her fear of going back to China and face the possibility, the 1 in 10 chance of possibility of triple ligation is objectively reasonable. Thank you, Your Honor.
Thank you, Mr. Lee. Ms. Watson, for your helpful arguments, and the case is submitted. And we'll hear argument next in Honolulu Civil Beat, Inc. against Federal Bureau of Investigation.
Good morning, Your Honors. May it please the Court. Brian Black on behalf of Honolulu Civil Beat. I would reserve 3 minutes for rebuttal.
Just keep an eye on the clock, please.
Yes, Your Honor. Civil Beat made a FOIA request for 2 closed FBI investigations. Senator English and Representative Cullen have been released from prison for over 2 years. The FBI takes the extreme position that nothing from its internal files can be disclosed about those public prosecutions.
Well, that's a little more than they did. They said there's some part of the files that won't be disclosed. That's what they said. And it's not a big part that is disclosed, but they didn't say that all wouldn't be. In fact, they disclosed some, right?
That's the word internal files. The things that they disclosed were all court filings.
Okay. But what they did was they produced a Vaughn index of what they were supposed to, of what they were producing and what they weren't producing, right?
They produced something that they called a Vaughn index.
Okay. All right. I don't want to argue about that. There was an index. We call it a Vaughn index, and you say it wasn't properly done. They produced 2 declarations in support of the application, right?
That's correct, yes.
The Vaughn index was about 30 pages.
Yes,
The Seidel declaration was 70 pages.
yes,
The Nohara declaration was another 5 pages, right?
correct.
Now, when I look at the Seidel declaration, and I'm just trying to look at these to see whether this is appropriate or not, when I look at the Seidel documents, or Seidel declaration, it categorizes documents, right?
It identifies 2 categories for categorical withholding. One is evidentiary investigative materials, and the other is administrative materials for withholding.
And it includes a table describing how the disclosure of the documents within those categories would be harmful, right?
It identifies a standard litany of harms, such as tampering with evidence, fleeing the country, creating alibis, things like that, correct?
Well, I don't want to go through each one, but I went through to see what they said. For example, they say information provided by interview subjects may reveal the identities of interview participants and/or other provided information. I mean, they went through each one and said why they weren't producing it, right?
That's correct.
Then another table with a description about the types of documents, right?
Such as emails, correspondence, 302s,
It
operational
says
plans.
documents include FD 302s that may be later used as testimony or evidence in court trials or proceedings. It says
Correct.
videos that are recorded images of surveillance activities. It says third-party information that includes documents or information received from third parties. I mean, it went through to put that together. Now, the reason I ask you that is I'm leading up to this question. I looked at Shanahan versus the IRS. And in Shanahan, we said the government's factual showing was sufficient. Seems to me this is the same as what happened in Shanahan. The government prepared a Vaughan index. They were arguing about whether it was a sufficient index. And the Vaughan index is not required. They provide an explanation of how the documents were selected. They provided an explanation of the harm that would be caused by the released documents. And they provided an explanation for why the exempt documents could not be segregated. I'm only reading this because that's what they said. So this seems to be Shanahan too. Why should I do any different than we did in the first Shanahan?
So Shanahan was different, Your Honor, because there were 3 rounds of summary judgment. The first round of summary judgment was the equivalent of what we have here. The district court in that case said that harms that were identified were too generic. And so then the court went through several other rounds of summary judgment, including production of records for in-camera review and eventually at the end. And this court had a much more robust record that the court identified as being a meticulous development of the record, which we do not have here.
Mr. Black, I guess maybe another potential sequel could be Lewis too. So Lewis, we have a footnote where we describe the affidavits, and I think I take your argument that you view the FBI as taking the position that any ongoing investigations of public corruptions, but so as a baseline, both Nohara and Seidel contain the recital that the FBI continues to investigate public corruption matters that are directly associated with the investigations into Mr. English and Mr. Cullen. So that's defining a scope and a basis. And then if I look to Lewis in terms of what the government gave us to work with there, it seems to contain a shorter recital of the details of the harms that would follow from disclosure into those ongoing investigations than we have here. So why doesn't it get over Lewis?
So Lewis, Your Honor, was the key to Lewis is understanding that the declaration of harm that the FBI submitted was not disputed. There was no dispute at all as to, by Lewis, as to the fact that revealing the information that he was requesting would provide information that he did not already have. And because that, the only thing that Lewis teaches is that when you have a set of records that are undisputedly exempt, you don't have to do a Vaughan index and you don't have to do in-camera review. That's what Lewis teaches. But what we have here, and what
So even for 7, but do you disagree that a Vaughan index would be futile for a 7A exemption?
if it's I think a Vaughan index is futile for any categorical withholding. And that's what we have here, and I think that's what needs to be distinguished, is that although, yes, they did all of this stuff in terms of the declarations and the Vaughan index, what they're asserting is a categorical exemption.
Oh, but as I understand, I guess there are different ways of viewing categorical as ambiguous. But as I understand, with respect to 7A at least, categorical descriptions are have been permitted. I mean, I get there are 3 categories here. Maybe you'd like to see more, but the ones that are withheld are the investigative and the administrative ones. And then those are tied to the recital that there are continuing investigations directly associated with this. And if there's a continuing investigation, it strikes me that in general, the courts have been pretty deferential to several categories of withholding under 7A.
I think the one thing, several differences, I think there, Your Honor. I think one is that categorical is not an ambiguous concept. It's a term of art. And the Supreme Court has been clear that when you have a categorical withholding claim, that is the standard there is that whatever the specified category is, it can be withheld always. So the example of that is a rap sheet under Reporters Committee. Doesn't matter what the facts are, in every instance, doesn't matter who the rap sheet's about, in every instance, a rap sheet is withheld under the privacy exemptions because the privacy interest is high, public interest is low, and when you balance it, it always comes to exemption. And when the court looked at categorical withholding under 7A in Robbins Tire, it expressly said that withholding records because they're investigatory would contradict Congress's intent when it amended FOIA in 1974. Congress expressly rejected the concept that, in prior cases, that said that you could withhold records simply because they were investigatory. And that's because what they did was in 1974, they changed it from before 74, it was investigatory files. But then after 74, the focus is on records or information. It's not on just categorizing it as investigatory files.
Right, but I guess if we take the Nohura and the Seidel, Nohura and Seidel together, Seidel has, we can, I guess, whether it's categorical or not it may be disputed, but as Judge Smith pointed to, it's quite detailed in terms of the groups of different files and the reasons why those groups of files that, again, it says, and that are related to a directly associated ongoing investigation. Why isn't that detail enough?
Because when you turn away from the categorical test, if you're going to look at it and you're going to look at the declarations, which look at things based on a fact-based withholding, so you're looking at it in terms of they say that they looked at it and they said it's good enough. They think it falls within the exemption. This court, there's several problems with that. I think this court has never simply deferred to an agency because they say that it's good enough. But it also, the problem there is that they're applying two different standards. Once you start looking at facts, this court has always required more information from the agency as far as showing their work. They have to show and connect the dots.
Well, I guess we've also expressed some concern that we can't require the agency to show something that kind of gives away the game. So what else would you like to see? What sorts of things do you think would be required in these declarations to support the exemption?
So, for example, just as one concrete example, and I think there are others that could be provided, there was a March 11 bribe where that we know all about that bribe. We have detailed verbatim quotes from that bribe that is in the public record. None of that information was revealed at all. Those records, there are definitely FBI records in their internal files that would reflect the exact same facts that are all publicly known. And this court's decision in Lion Raisin makes clear.
I guess what do you mean by it in terms of what is the, so for example, it could be a informant's account and you could see, well, the agency would have reasons to do that. It could be a transcript of a recording, but of course then the transcript might, then have a date associated which could also provide information. So can you just be a little more specific about what do you think is underlying there that would that the government should be required to provide more information about?
So we have, and it's not just it's not just information that's that would be required in a Vaughn index. I think they have to disclose those records. If there's a transcript that has the exact verbatim quotes that are recited in the plea agreements and in the sentencing memorandum, there is no reason that that information should be withheld. Whoever it is that is the target of some other investigation already has that information. And what this court said in Lion Raisin is that that's where the concern about interference comes from.
So if the counterparty is a potential witness in in one of these directly associated investigations, and I guess you don't dispute that there are directly associated investigations going on. We can at least defer to that point that there is an ongoing investigation for purpose of the elements of the test.
That's correct. And what we would say is that you can't categorically withhold. It is not always something that can be withheld simply because there is some investigation that's ongoing. And that To have that type of categorical withholding would be completely inconsistent with Lion Raisin, because Lion Raisin, there was an active investigation, and the issue was whether or not the information was available to the target. And here we have information that was available to the target, has not been disclosed, regardless of whether there's an active investigation. Not everything should have been withheld. And that's the key point. And I'd like to reserve the rest of my time.
Thank you. We'll give you 2 minutes.
Thank you.
A moment. Thank you. May it please the court. Turning with the first exemption, 7A. All the FBI has to do under clear, settled Ninth Circuit law is demonstrate that the disclosure would interfere with enforcement proceedings that are pending or reasonably expected. And again, under Ninth Circuit law, categorical withholding under exemption 7A is appropriate.
So underlying reasons, it says, with as much factual support as possible, just to pick up where we left off with your friend, why would it not be more possible? Or it's clear that there are transactions that were charged here that have some evidence in the internal files that is not present in the court filings. Why couldn't the agency provide more support for some of those categories of documents?
Well, as Your Honor's own question previously also pointed out, is there's extensive case law that says the government is not required to give out its cards. It doesn't have to provide more facts, more dates, more information that would reveal the scope, the nature, the pace, the direction of the ongoing investigation. And that's what would happen here. That's
I guess it's difficult because we have a closed case, and there's a set of cases about the closed case, probably much harder for the government to withhold under 7A. And then we have kind of, seems like it wouldn't be enough to just say we have ongoing public corruption investigations into the Hawaiian state government or legislature. So, I mean, you may disagree, but it doesn't seem like our cases take us that far. So what we have here is a statement that there are ongoing investigations directly associated with these defendants. Is there more that the agency could say to give the court and the public something to work with under 7A?
No, and I don't think any more is required under 7A, Your Honor. It's the Ninth Circuit gives special or considerable deference to good faith declarations by people with knowledge. And we have two of those. People with knowledge, somebody here local, Aaron O'Hara is on the ground, he's a special agent, discussing how releasing any more information would be problematic. There
I mean, we're asserting that releasing any more information would be problematic, but I think the point of the question is not really explaining how that is, and in particular, how that can be true with respect to all of the many thousands of records here in an investigation about two people who were already convicted and one person who's now dead, right? And so I guess just on the face of it, it's just sort of hard to understand how there's nothing in there that isn't just about those people and doesn't really have anything to do with the other person or persons who may be the target of the ongoing investigation. And then I think the explanation of that is what I think is not present in either declaration. So how do we fill in that gap?
And I think Mr. Seidel elaborates more on the breadth of in those two tables were referenced in paragraphs 40 and 41 of his declaration, where he describes the types of forms, the memorandum, the handwritten notes, the source information, where there's information related to other witnesses.
But I guess as your friend kind of point, I mean, so Mr. Seidel's in Washington, D.C.
Yes.
He's is kind of above, not a local person, not involved in this investigation. Either the past one or the current one in terms of
He's not the boots on the ground,
investigation,
correct?
right?
That would be Aaron O'Hara.
But it's just in looking at it, I take your friend's point that this looks a little boilerplate like. I mean, yes, if it's true that, you know, if we accept the premise that there's an ongoing investigation that are directly associated with these defendants, and that these documents relate to that ongoing investigation as opposed to the past investigation, sure. But as to every box on these charts, there's no particular detail in these charts that kind of close that loop.
What other detail could be provided? I mean, if we're talking about names, witnesses, informants, locations, dates, that kind of information is exactly what would reveal the very information that that the FBI is trying to
Let's
protect.
take, for example, conversations that we can assume have been recorded somewhere in these notes or something that are between the key counterparties to the past investigation, where you have two people who are known to be convicted and sentenced, and a counterparty who is deceased. Are there documents? It's fair to assume that there's probably documents, transcripts, other things that are recording those transactions?
Well, if we look at the Vaughn Index, which is extensive, and compare that with the declarations, we can see what the recordings are and the basis for those withholdings. But we have, and just to clarify for the record, Milton Choi was a confidential informant. Civil Beat apparently has taken the position that he was the only confidential informant, which is based on pure speculation. We have Seidel's declaration that says there's more than one that should.
That's why I asked you only about Mr. Choi and the defendants, the known defendants.
So we have the declaration of Aaron O'Hara, who said he reviewed the segregability determination, he reviewed the file, and he confirmed that the information contained in resulting from their search in the FOIA request is so intertwined that it cannot be reasonably segregated.
So is the answer, I mean, so I thought, well, I don't know whether this was the question. Here's my question. So if somewhere in the files there is a document that is just a record of a conversation among Mr. Collin, Mr. English, and Mr. Choi, talking about a transaction that was the basis for one of the charges in this case, it's your view that release of that document, which doesn't say anything about any other confidential informant, doesn't involve anybody else, release of that document would interfere with the ongoing investigation?
I don't think I can answer it that way for two reasons. One, I cannot confirm that that particular document exists, that there in fact exists something that is only between three people, that doesn't involve anybody else, that no one else participated in, that doesn't release, that phone call, transcript, what have you, doesn't include relation or information related to something else.
Let's call it a hypothetical then.
Hypothetical, thank you. I cannot answer that hypothetical the way, because I don't know that that exists. I'm not the one.
Now that it's hypothetical, you can't.
Let's suppose it does exist.
Well, in that case, if there is zero information contained in that transcript that has nothing to do with anything of the ongoing investigation, I don't think that exists based on the two declarations we have in front of us.
And where would I look in the declaration to confirm that no document like the one I just described exists?
I think that is a combination of Nohara's declaration at paragraphs 10 through 14 and Mr. Seidel's declaration in his, where he discusses each of the categories, and then his segregability citation is paragraphs 128 through 129 of his declaration. That's 3 ER 355, I believe. And then I think also we can
if the court would like, we can go through the Vaughan Index and look at every single, if we want to move beyond the categorical withholding and look at the basis for every single document that's been identified has multiple reasons for being withheld in whole, in part, or in part. And then when you pull out what could possibly be produced that's not redacted, if we go through line by line and redact all of the appropriately withheld information, all that's left would be meaningless. It would be and the nonsensical, which again, Seidel and Nohara have tested to is meaningless when you look at the totality of the page.
So could you address the DC Circuit's decision in Crew 1, the 2014 case? So, because that seems to me to be fairly similar in that you had, an investigation of somebody that was convicted and an investigation of, there was Mr. DeLay that was publicly announced that the investigation of him had been concluded, and the request is for records of that concluded investigation, and it's withheld on 7A because it might affect a future investigation. And the DC Circuit said, essentially, maybe you can justify this under 7A, but you need to tell us something about why the records from this closed investigation, why and how they're going to implicate the future one. And this just sort of blanket assertion that they're all tied together isn't good enough. So why isn't this kind of like that?
Crew is a really interesting case. It originated with the investigation into Jack Abramoff. And that started with him, led to the 21 convictions or guilty pleas of others, 2 of whom were the top aides of Tom DeLay. So with the request for information, and the last person standing, the senior-most person in the investigation announced publicly that the investigation into him was closed. And the question of that the court considered there was, why did the FBI and the DOJ go after everybody but Tom DeLay? Did something nefarious happen? Was there dealings? What's going on that they prosecuted and convicted everyone but him? And when it got to the appellate court and the question was, well, is the investigation ongoing? Is it closed? Because everybody's done and you have a letter saying everybody done. The DOJ attorney said, well, it is in fact closed. All we have left is this appeal. And that didn't satisfy 7A because it was in fact closed. That is not the case here. This could not be more different. We do not have a closed investigation. We have 2 declarations saying the investigation is ongoing. In anticipation of a question like this, I spoke with Agent Nohara recently. He confirmed that the investigation is ongoing. Nobody has been informed that the investigation is closed.
Let me go a different way. This is close to where I am, but in general, when I'm looking at these, I'm looking at the government withholding documents while they're investigating individuals who are subject to the document requests. So they would be those who are already being persecuted or whatever. In this particular situation, we're not after those kind. We're withholding documents about an investigation into third parties who are not the target of the document requests. So to me, when I read the DC Circuit's Citizen versus Responsible Ethics in Washington versus U.S. Department of Justice, the DC Circuit said, hey, there's not as much reason to help the government in those situations with the third parties. And in fact, the DC Circuit ordered a remand because they were less inclined to infer harm to the government. Now, I said to myself, why is that not something I should do here?
I think this case
This is not about second parties. This is not about the parties who are the subject of the investigation. This is about third parties. And it seems to me that the DC Circuit's kind of set out the way we ought to go.
Well, I think if we look back at at the original FOIA request. They requested all documents and records that may have been gathered or produced between September 2014 and February 2022. All investigative reports and materials maintained by the FBI relating to criminal charges brought against Cullen or English. Anything related to the criminal investigation. And it happens that encompassed in that very broad request, any and all materials gathered or produced in a 6-year time range have to do with other investigations. I think this is more like the Boyd case out of DC, where the DC Court of Appeals. In the Boyd case, an individual criminal defendant was convicted, his appeal was affirmed, and he thought he had a case against an informant and FOIA'd those records. The DC Court of Appeals agreed with the Department of Justice and said, just because you're convicted, just because your case is over, doesn't mean we're not using that confidential informant for other cases that are ongoing. And that's the case here. Just because that one is done doesn't mean we aren't using investigative techniques, confidential informants, witnesses, sources.
But that wasn't that true in Crew there? I mean, the district court there said that, and the investigation was still ongoing. There were people who hadn't been sentenced yet, and there were cases still going. And what the court said was, quoting here, the relevant question is whether any of the responsive record, assuming some individuals remain under investigation, the relevant question is whether any of the responsive records, which are primarily about delay, would disclose anything relevant to the investigation of those individuals. And it seems like the same question can be asked here. Like, no one's disputing that you have an ongoing investigation of some person or persons. This is a request for information about, 2 people who are convicted and 1 person who's deceased. And some of it might have to do with those other people, but some of it might not.
And I think the FBI took that guidance from Crew and created this very extensive declaration based on that provided the specific roadmap, the tables and the descriptions, the 7A, the categorical withholding is described by Seidel, in 7 pages of information. That's just 7A, notwithstanding the other investigative components. 7D, which relates to confidential informants. 7E, which relates to investigative techniques that are not known that would interfere with the FBI's ability to conduct investigations into widespread public corruption.
But just to take one example of Mr. Seidel's categories, on page 18, he says, information provided by interview subjects. And then we get a paragraph describing, how interviews work and sort of what is in interviews, which, I don't think anyone would question any of that, but it seems to beg the question, which is, are these interviews about anything that's relevant to the investigation that's still ongoing, or are the interviews just about something that's done? And that's something he doesn't say anything about.
What Seidel and Nohara say in the span of the 6 pages of the 7A declaration is that these categories of documents exist, and if they were revealed, they would impede the ongoing investigation because they would thwart it by revealing the scope, direction, pace of the investigation. They would alert witnesses, they would alert potential targets.
I guess to focus on the key sentence here in both of the affidavits, the information evidence contained in the FBI's investigatory files could be used in the government's future prosecution of corruption by other public officials. Not likely, which sometimes we've seen is the test, there's lots of stuff that could be used that doesn't necessarily answer the question that 7A presents. That's the only thing other than general discussions of FBI investigative techniques and resulting materials and the types of general harms that might flow from those that either of these declarations have. Why is that enough?
I think that is the Hamden case, Your Honor, and the Lion Raisins cases, both the 2004, 2007, and the Hamden cases. All of those Ninth Circuit cases say that we can take the declarations at face value absent any contrary evidence in the record. We do not have any contrary evidence in the record.
Do you
We
agree,
have-
agree with your friend's reading of Lewis in terms of the affidavit there? The affidavit there seems to be a little less than what we have here, but it is quite a hard case to read to try to figure out what exactly we found was sufficient and what the case was about. What should we do with Lewis?
I think Lewis stands for the proposition that categorical withholding is appropriate when you have sufficient information. And I think we have that here. And I
Is
think
it a holding that that is sufficient information, or do you agree that that wasn't actually at issue because the sufficiency of the affidavit was not in dispute?
I do think that the sufficiency of the affidavit was in dispute. I think in that case, there was a combination. I think at one point there were 3 affidavits, but no Vaughn index. And there was a dispute as to whether there was enough information gleaned from that combination of what was provided. I think there the district court and then the appellate court agreed that it's function over form. You can have 3 declarations, you can have 2 declarations and a Vaughn index. What matters is the information that's presented. And there it was decided that the Vaughn index was unnecessary because of the categorical withholding. Because 7A categorically protected the ongoing investigation, a Vaughn index wasn't necessary. I think that's our position here too, but just in case the court didn't agree with the 7A categorical withholding, the FBI went ahead and briefed everything else so that every single exemption was identified and explained in sufficient detail, warranting substantial or considerable special deference that's awarded to the declarants by the Ninth Circuit Court of Appeals. I see I'm substantially over time. I thank the court and I ask the court to affirm.
Thank you. We've been talking about the DC Circuit a lot, so we're doing a DC Circuit style time limit enforcement this morning. Mr. Black, rebuttal.
Just a few issues, Your Honors. The counsel discussed there was a broad request. If the FBI interpreted it as a broad request, they still need to produce what's not exempt, and that didn't happen. With respect to whether there's contrary evidence in the record, I think the fact that there are public facts available to the whoever the target is in this other investigation, that is contrary evidence in the record. It's not addressed by the declarations. The declarations should have at least addressed the fact that there is public information available and whether or not that could be disclosed specifically. And with respect to Lewis, just quoting from Lewis, quote, it's quote, undisputed that release of the requested 700 pages of the documents would reveal, among other things, the limits and scope of the IRS's case against Lewis. And then also, quote, Lewis does not rebut this statement. So Lewis was not about the sufficiency of the declarations in that case because it was not disputed as far as...
At the beginning of that paragraph, it says the affidavit submitted in this case described in sufficient detail the undisclosed materials.
Certainly sufficient for purposes of undisputed, yes. But when you have, and I would point the court, this court, whenever this court has given substantial weight, deference, whatever it's called, it's never simply just accepted the agency saying an exemption applies. We've looked at this based on our say-so, an exemption applies. The agency has to earn that weight.
What is it that you dispute, and what are we supposed to do with that, given the deference and the de novo review and summary judgment? Can you be a little so point us to where we should look to see the underlying facts that you dispute that would undermine the sufficiency of the 7A exemption?
So again, taking it to a specific bribe, right? I think the
Is that in the, I guess, where should we look in the record, right? Again, pretending that this is an ordinary summary judgment case, it doesn't look like that tends to be how we treat them, but where would we look to establish the more that the government needs to come forward with to put those disputes to rest.
If I understand the question, and I apologize if I don't understand it correctly, but if I understand the question, I think that there is evidence in the, I don't think the record is undisputed as to what is publicly available. And the dispute comes from whether or not the declarations address that information, and they don't. So the public information that's available is about the bribes. It's about the information that's in the plea agreements and in the criminal information, in the sentencing statements, in Cullen and English's prosecutions. All of that information is publicly available. It's detailed. It has verbatim quotes, and yet none of it is addressed in the declarations. And the problem is that this court, on a de novo independent assessment, needs to be able to track and support what it is that the agents are saying as far as the exemption applies. Because when you're doing fact-based withholding, and again, distinguishing fact-based and categorical, they're claiming categorical. Categorical means that it's not just this case. In every case, investigative materials can be withheld because there's a pending investigation. That's clearly not the standard. So if you're talking about fact-based, they have to show their work. They have to show how the lines connect. That's what Crew requires. And a good example, when you talk about deference, a good example from this court is Weiner. Now, while that case was not a 7A case, it was a national security case. And what the court said in that case was, it's not a reason, I'm paraphrasing, but it's not a reasonable inference, just based on what the agency is saying. And then they cite the litany of standard harms, similar to what's here. They say it's not reasonable given all the facts and the evidence. And here, when you look at all the facts that are in the evidence, all the public information that's available, the idea, and this is what Crew is getting at, the idea that is it objectively reasonable that releasing the information that is publicly available, that's a verbatim quote from Choi in English, is that going to cause harm?
All right. Thank you very much. We thank both counsel for their helpful arguments in this case. The case is submitted and we are adjourned.
All rise. This court for this session stands adjourned.
Wait, you don't write anything?
While I am trying to find another one, so we can round off the rest of today, I really don't think that Lisa's little lawsuit suing Megan and them for copyright is actually going to work. I really don't think it's going to work. See if I can find a short one. I know there were some short ones in here. Yep, here we go. I really don't think that lawsuit's going to work. Because, see, you're stupid. You went public with it, with your live stream. Just like this live stream is public. So if anybody wanted to get clips, screenshots, and transcripts, they can do it while it was public. You can't claim that people were getting this content while it was under a paywall. If it was public before you put it under a paywall and they got the stuff, you can't claim that it was under a paywall when you went live. Oh, Lisa, what the fuck am I gonna do with you? And the biggest mistake that you're making, there's two big mistakes that you're making in all this. Is number one, you're going on your live stream and you're telling people what you're gonna do to people in court. And number two, you're listening to paint chips and lips who are disbarred lawyers who can't giving you legal advice, and they can't give you legal advice because that's the unlawful practice of law. So you're listening to Luthman, and you're listening to how do you say her name? Federico's, who are disbarred lawyers giving you legal advice. And technically, by law, they cannot give you legal advice because that's the unlawful practice of law. They're disbarred. They don't have a license anymore. But yeah, you can't claim that Megan and Tug was getting your content while I was under a paywall. If it was public when you went live, you were public. Just like this live stream is public. So if they got screenshots and whatever, they got it when it was public. You can't go to court. Good luck going to court and telling the judge that they got it while it was under a paywall. Nobody in their right fucking mind is going to pay $500 for a membership. All right.
Good morning, Your Honors. May it please the court, Dale Ogden for Nathan Mason. I'll try to reserve 2 minutes of time for my rebuttal, and I'll watch the clock. Mr. Mason repeatedly let counsel know, let the court know, and testified that he was innocent of these charges, that he was sober in his right mind, and that the victims were lying. After counsel had conceded otherwise, he even spoke up at closing, yelling, "I'm innocent," before he was escorted out of the courtroom. He thus meets the first prong of McCoy, seeking to persist in his innocence. Based on the briefing, I think the second prong, that counsel conceded guilt, is where most of the dispute lies, so I'll turn there unless the court would like to direct me elsewhere. The core error in the state's position, I think, is what conceding guilt means. Conceding guilt, as used in McCoy jurisprudence, means either implicitly or explicitly admitting factual guilt, the actus reus, or raising certain mental state defenses that the client has a right to prevent. That's McCoy and that's Reed. With that correct understanding of McCoy and Reed, that's what happened here. Mason is saying this did not happen. His attorney is saying, yes, threats were made, but when threats were made, he was not in his right mind. He was intoxicated, to such a degree that he didn't understand his actions. And that's precisely the same, it's the same thing that happened in Reed, and it's the same justifications that really would allow Mason to prevent his attorney from raising that over his objection. I think the magistrate judge really grappled with this and came close to this, to granting relief here in some ways, because what she explains in the R&R is Mr. Mason and his counsel are clearly acting at cross purposes throughout trial. What she did was, the quote is, hardly a model of client-centered representation. That's correct. That's precisely the right that McCoy enshrines, is the right to be the captain of the ship. The defendant is the captain of the ship, and we as the attorneys provide the assistance of counsel, and you don't act contrary to your client's wishes.
Is that at every step? Can your client dictate every single step in the litigation?
No, most things are arguments, right? And that's Gonzalez. Most things fall into the argument camp. But where we are here is conceding. What counsel can't do is concede guilt, with the definition that I give.
So I guess my confusion is, I understand that as a kind of big picture thing, but here, when counsel said, or potentially said, let me paraphrase, yeah, maybe he did commit that, but he was so drunk he didn't know. And therefore, he didn't have the proper mental state to be found guilty of that particular crime that required that enhanced mental state. Is that still the same thing? Is that still, because aren't they at the end of the day trying to get the same acquittal, so to speak?
So I'd push back a little on two things. One is what counsel was doing at closing. She does explicitly say when the threats were made, Mason had no clue what he was doing or saying. So I think the threat count is actually probably the most clear here, that she is acknowledging threats were made. That's the actus reus of that offense. And the line is the same line that was drawn in McCoy, is you're not conceding factual guilt, right? Throughout McCoy explains it's not just the technical acquittal. And in a case, Chambers, this is a denial of cert dissent by Justice Sotomayor, but she explains, we made clear in McCoy that it's not just the technical acquittal, it's factual innocence. It's this didn't happen that we're concerned about. Because throughout McCoy, they describe the right as avoiding the concession that Mr. McCoy killed his family. Not that he was guilty of first-degree murder, that he did a killing, right? What McCoy's counsel, Mr. English, was doing was actually a pretty common defense. He's saying, yes, this act happened, but no, he lacked the requisite mental state. And the Supreme Court there is saying that's still a violation of the right. And the reason, I cite all these state cases as well is in McCoy itself, the Supreme Court flags 3 state Supreme Court cases and cites them favorably for the proposition that when you concede factual guilt in pursuit of a mental state defense, like lack of premeditation, those type of things, that still violates the right.
So here's what I'm confused about, and it may be just my ignorance of the law, but so it seemed to me what Mason wanted to argue was a different version of the facts, where what he was doing was acting in self-defense. And so he said he wasn't drunk, so he and his counsel were contradicting each other throughout this thing. But he wanted the self-defense to be asserted as.
Did you lose or damage your car key fob? Did you know that more than 26% of drivers lose?
As I understand the self-defense argument, yeah, I did these things, but I did them in self-defense. And they started this altercation. They came after me first, and then I had to shoot off the gun to protect myself. But that's still admitting that some of the actus reus, right?
Well, where I'd push back is what Mason wanted there, because I think the self-defense, as Your Honor mentioned, it applies to the negligent discharge count, because that's where he's saying.
Right, that's the various counts.
Yeah, this is where it gets a little
confusing.
Right. So I probably should have done a better job of this in the AOB.
Right.
So it's the negligent discharge is what he's saying. That's where, I shot it off to scare them off. They ran. That's where that one applies. For all the other counts, he is saying this did not happen. Full stop.
That they're lying.
Yeah, he did not put a bullet through the door. He didn't assault them. He didn't make threats. That type of thing. So that applies to the other counts.
But didn't counsel, I'm sorry.
Oh, I'm sorry. I'm just trying to remember what all the counts were. Like, can you give me an example of the count where the voluntary intoxication would come in as a defense?
Well, it's an interesting question, because where counsel raises the voluntary intoxication is counts 4 and 6.
Okay.
The threats and the negligent discharge count. Again, I think the threats count is pretty clear, because he's saying, she's admitting the threats happened. For 4, it's beyond me, because voluntary intoxication is not a defense to negligent discharge. So actually, by raising that defense, she is admitting guilt, period, even under the state's pretty narrow definition. much like McCoy, where English was raising a mental state defense that probably didn't exist under Louisiana law. She's raising a mental state defense that does not exist under California law as to count for the negligent discharge.
Counsel, I want to ask you a hypothetical because it will help me understand your position and how we interpret McCoy, and the circuits are all over the place on this issue, as I think you've acknowledged. All right, so here's the hypothetical. It's a sexual assault case, and there is DNA evidence tying the defendant to the victim, and there's the victim's testimony saying that they had sexual intercourse, but it was not voluntary, so it's a sexual assault case. The defendant tells his lawyer, I didn't have sex with her. I don't want you going up there and saying that I did, despite all the evidence to suggest that something happened. The defense counsel wants to argue it was consensual. The defense counsel thinks that's the best way out of this case, and there's some evidence to support the idea it's consensual. In that situation, if defense counsel makes the consensual argument rather than the it never happened argument, would that be a violation of McCoy in your view?
So I think the answer to this is found in Justice Alito's dissent in this court's decision in Christian. The answer is if what counsel says, and Justice Alito actually compares these two situations. He says if what counsel did was admit to the actus reus, admit to the sexual contact, and then say, but it was consensual, that's a problem. But if what counsel does is say, we don't know what happened, we weren't there, but whatever happened, here's the evidence that it would have been consensual, that is okay. And I understand that's a fine line sometimes, but that's the line that Ferretta and McCoy have drawn is that a right is you have a right not to admit to criminal acts, to the actus reus of an offense. That there's a lot of good reasons why somebody might want to push back on the idea that there was sexual contact like that. So you can raise defenses, like consent, but you can't acknowledge that the acts happened.
So it's almost when, there's that word autonomy, I think, is used in the opinion, which, candidly, that can mean a lot of different things to a lot of different people. Your view of what that word means is like the defendant has his story. His story. He's allowed to tell his story, and the lawyer cannot contradict his story. Is that one way to look at this?
I think that's probably a little bit broader than what I'm saying. It's not the story as a whole. It's the actus reus of an offense, right? Because when you admit to something like a killing or sexual contact or whatever, there's a right for the defendant to persist in his innocence there. There's a right to say, I didn't do that. You can't concede that. And the lawyer can do any number of things at that point. The only thing she can't do is concede it, right? The lawyer still gets, like we were talking about earlier, Your Honor, the lawyer still gets to focus which arguments they think are best or whatever. But in doing that, they just can't concede that it happened.
So they can still argue reasonable doubt. And there's all the typical things you're saying they can argue.
Certainly, yeah. The whole world is still open to a defense attorney. Now, I mean, there is.
Before you move on, I'm sorry, I just want to clarify. Does that also extend to affirmative defenses? Can my client tell me, I want you to say that it was consensual in Judge Owens's example?
That's a tough example because I don't know if that's an affirmative defense or if that's an element of the offense. But assuming it's affirmative, I think McCoy answers this the cleanest, and it says like, well, the Louisiana ethical rules might have prevented Mr. English from raising a frivolous defense or a defense he knows is false. But what he can't do is admit that it happened. So I think the answer is a client can not force an attorney to raise a defense, an affirmative defense, for which they know is false, right? That's the McCoy line. But on the flip side, there are a lot of cases that suggest if the attorney is raising an affirmative defense, and the affirmative is probably a misnomer. It probably doesn't matter whether it's affirmative or not. But when a client is saying, don't do that, that's where McCoy kicks in and says, no, okay, you can't concede it, right? If the client says, don't argue self-defense, what the attorney would have to do to argue self-defense is get up there and say, yeah, he killed them, but it was in self-defense, right? You're going to create a McCoy problem when you raise that over a client's objection.
And so when is it a McCoy issue versus when is it a Strickland issue, an ineffective assistance of counsel issue?
They are distinct in almost every sense, right? McCoy is structural. Strickland has a convoluted prejudice standard, that type of thing. The line is in an autonomy right of the client. If it's not in that camp, yeah, everything else is going to be in the Strickland camp. The question is it the client's right under McCoy? Is it an autonomy right? And I think what McCoy and Reed stand for the proposition that we put forward, that that's implicitly or explicitly admitting guilt or raising these defenses that a client has the right to prevent. I'm sorry, I'm well over my time. The court has no other questions.
Oh, no, I mean, because the circuits are everywhere and people are struggling to interpret McCoy, it's, and apply it in this case to these facts. Both sides can have extra time. It's a very difficult question. So thank you.
If I could address that, Your Honor, I don't think the court needs to wade into the circuit split either, because obviously Walters, for example, conceding an element only is a McCoy violation. That is a split with the Second Circuit and Roseman, for example. But the consistent through line is conceding the actus reus. So,
and here that you're arguing the attorney conceded the actus reus because she said when the threats were made.
This is a nanospray from Germany. It uses graphene and ultra-durable technology found in aerospace.
Right, for those.
So acknowledging the threats were made.
Yeah, again, the threats are, I think, the clearest ones. For the other counts, it's sort of what the magistrate judge says, is she's acknowledging that the victim's story is correct. She's actively disagreeing with her own client. She doesn't ask for a not guilty. She just says it
The oddest
just.
thing is that he gets on the stand and testifies, this is all a lie, da, da, da. And then the attorney comes on and says, no, this is what happened. That was just strange to me reading this.
I have the same intuition, and I think that intuition is the autonomy right for McCoy, is that if your client gets up there, that's off limits in a way, in addition to being obviously terrible strategy.
And also perhaps a Strickland thing by him I mean, it could be both McCoy and Strickland.
Oh, there's plenty of facts where it could be both, but I do think this falls into the McCoy camp.
All right, thank you, counsel.
Thank you, Your Honors.
Good morning, and may it please the court. Gabriel Bradley for the respondent. McCoy prohibits a lawyer from making an actual concession of guilt over her client's express objection, and the holding of McCoy goes no further than that. If a prisoner disagrees with his attorney's choice of defense strategy, that is a Strickland claim, not a McCoy claim. Likewise, if a prisoner believes that his attorney should have been more aggressive in closing argument, that is a Strickland claim and not a McCoy claim. However, Strickland claim does test for prejudice, and perhaps seeking to avoid having to test for prejudice, Mason attempts to frame his complaints about his attorney's performance as McCoy error, which would be structural error. But McCoy is limited to the rare occurrence of an attorney overriding their client's express choice of the fundamental goal of the representation. And that only makes sense because that would be a structural error. But here, Mason got to choose the fundamental goal of his representation, which was to seek an acquittal at trial. And his attorney honored that choice by going to trial on his behalf and seeking an acquittal at all times throughout the proceedings. Their objectives were aligned.
So what's interesting is that if you say, oh, they both have the objective of being acquittal, it's such a general abstract level that you could say that in every case. Everybody wants to be acquitted. But at what point can the defense attorney concede conduct as opposed to, conduct in the goal of acquittal against the client's objections? For example, this attorney here said when the threats were made. Do you agree that that was admitting or conceding or acknowledging that her client had made the threats?
No, Your Honor, we don't acknowledge that that's what the attorney did here. The whole sentence in context is very equivocal in its language. I would submit to you that I believe there's evidence to support a finding that at the point in time the threats were made, Mr. Mason had no clue what he was saying or doing. He'd been hit on the head. He'd been drinking. So the issue.
I'm not sure that's the sentence I'm referring to, but
the only time when she makes the statement.
Okay, but okay, fine.
So she does. So what is permissible is to argue in the alternative, present different points of view, and to argue that she's not saying that these things did happen, but she's saying I believe that there's evidence to support finding that. So we don't agree that she was conceding the threats happened. There was no testimony from Mr. Mason regarding whether he did or didn't make these statements, and so she doesn't really get into it very much in her closing argument. What she does do is argue that because of the head trauma that he received and because of evidence showing that he may have been drinking, even though he disclaimed it in cross-examination, that was enough to support a finding that the mens rea element had not been met here. So she's allowed to do that. She's allowed to go after the element that she views in her professional judgment is weakest, the one that she believes she has the best chance of knocking down. That's a strategic call by an attorney, and she's well within her ambit to make that decision. That's not depriving him of his fundamental right to choose the fundamental objective of his representation. And that's where, yes, McCoy is at that big, general sort of big picture issue because it's structural error. That's what we're talking about here. Somebody who doesn't want to plead guilty, but instead wants to take this to trial and seek an acquittal, that person, if that decision that he's made, it gets overridden by his attorney over his express objection, that is at that general level structural error. And that's why McCoy treated it that way.
Counsel, I am sorry to interrupt, but that's the exact point I'm kind of stuck on. He specifically said several times, I wasn't drunk. I wasn't drunk. I wasn't drunk. And then she goes up there and says, maybe he was so drunk he didn't realize he was drunk. How is that not going against his express wish?
Hey, put this on!
To say, hey, I didn't do it. Not just what she said, he may have been so drunk he didn't realize he did it.
So that happened later in the trial, and that's one of the things that is pointed out by both the majority and the dissent in McCoy, is that things happen in trial, and the attorney needs to be able to adapt. And so what happened here was she advised him not to testify. He chose to testify. That's fine. He got through his direct exam just fine. And then when he's being cross-examined, what happens is the unexpected happens on cross-examination. That's usually why you're not advised to testify. And when he was being cross-examined, the prosecutor gets into this issue of you didn't drink. And he goes along, in cross-examination, he admits, yeah, you're right, I wasn't. So the attorney then says, outside the presence of the jury to the judge when they're discussing instructions, I'm in a bad position because I came in with strategy A, and now he's gone into and thrown this out. That kind of thing happens in trial, where the actions of the evidence or the client's choices, whatever it may be, turn out different than the attorney was anticipating. That's not him being deprived of his right to control his decision about whether to plead guilty or to seek an acquittal at trial. And that's not his attorney abandoning him. What that is the attorney has to make a professional judgment about the best way to go forward. She said, I have to think about it over the weekend. She came back, she tried and walk that tightrope of saying, well, there is evidence to support a finding, so that's why that's equivocal language there. You see in the, so she's doing the best with what she's got, but there's no Sixth Amendment requirement to take a sow's ear and turn it into a silk purse. What she did was the best she could. Failure to come up with a better strategy, that could be tested under Strickland to see if that's some sort of prejudicial error there, but it's not structural error. It's not him being overridden in the fundamental goal of representation by his own lawyer. Their objectives were aligned. They both wanted this jury to find him not guilty. He was doing what he felt was in his own best interest, and she was using her professional judgment to do the best she could with the facts of the case to try and win an acquittal for him. But the choice of one defense strategy over another and debates about the merits of a particular affirmative defense, that's not structural error. And a strategic choice to concede an element, that's not structural error either. Failure to be as aggressive as an attorney might want, as a client might want his attorney to be, that's not structural error. So we're outside the realm of McCoy. We're talking about the things that Strickland is amply suited to deal with.
So can we go back to the hypothetical I asked your opposing counsel, because I want to get your take on this. Again, it's a sexual assault case. He insists that no sexual contact occurred, but there's DNA evidence and the victim's testimony suggesting that it did happen. In your view, can defense counsel go up there and argue it was consensual, even though the defendant does not want counsel to admit any sexual contact?
I agree that so it's certainly no problem at all if he argues the if the attorney argues in the alternative and says they haven't proven that there was sexual contact, but even if they did, it was consensual, right? That avoids this problem of the client doesn't want to admit that. The problem with that, though, is it's not a persuasive argument, and it loses credibility with the jury if you are asking them to completely ignore the DNA evidence and the confession, all these things. So it is a professional judgment within the attorney's ambit to say, I know that's not a persuasive argument. I have a chance to get an acquittal here, which I know is your goal of representation. I'm going to get up in my closing argument and I'm going to say, yes, the evidence shows that this happened, but here's all the things that support consent. That is a strategic choice. That's based on professional judgment about what's going to be persuasive to a jury or not. That's exactly what an attorney is well suited for. And it's clear from McCoy that an attorney cannot have their closing argument dictated to them by the client.
So, but let me ask you about that, because McCoy has, there's some language in there that's, for me, I have trouble understanding exactly what they were trying to accomplish. But in that situation, if the defendant says, look, this is really important to me for religious reasons, that I don't ever concede that I had sexual contact with someone who's not my wife, I want to stay married, and if I concede I had sexual contact with someone else, I'm going to get divorced. These are really important things to me. In fact, those are more important to me than even this conviction. It's that important to me. Even still, you would say, under McCoy, defense counsel could go against the defendant's wishes because the ultimate goal is acquittal.
So those would all be reasons why the client may not want to testify and have to answer the questions about that. But as far as what the lawyer says in the lawyer's closing argument, because they're not saying that they're admitting that the strength of the government's evidence is such that it's not worth fighting that element. But we are going to fight on these other elements where we feel that there's a weakness in the government's case, specifically the consent in this situation. It's very similar to what happened here. Is there was the strength of the evidence about him being there, shooting the gun. There was an uninvolved third-party witness who saw it. So it's a professional judgment for the attorney to say, we can't win by going that way and fighting that part of the case. What we can do is we've got this low-hanging fruit here of the mens rea element, which I do think we have a shot at. We can knock that down. And that's where I'm going to focus my efforts. That's where I'm going to focus my energy, because I know we're just spinning our wheels and losing credibility in front of the fact finder if we spend time on this other thing that's going to be a distraction.
But what about the negligent discharge count? Because that count, she conceded the negligent discharge, and she argued voluntary intoxication. But voluntary intoxication under California law is not a defense to negligent discharge because it's a general intent crime.
The only pants you'll want to
So what about that one? Is that at least more clear for you?
So, and I note that my time's expired, but it's,
Oh, do you not want to answer
no,
the
I
question?
just want to. I don't want to be talking. No, I'm happy to answer the question.
Okay, please.
So I disagree with the characterization of the record. What she said, she starts to go down that road and then corrects herself. She says shooting in the air, shooting in a reckless manner, and then she herself says it's a general intent crime. And then she pivots to circumstantial evidence. It's circumstantial evidence that a person who later threatens someone has no clue what's going on and is drunk. So she goes again to it's circumstantial evidence. So what the magistrate judge found in the report and recommendation was that the defense there had to do with sufficiency of the evidence, which is always an option to go after the sufficiency of the evidence, say the prosecution didn't meet their high burden of proof beyond reasonable doubt. And what the magistrate interpreted the record, and I agree with it, she wasn't trying to hang her hat on mens rea because she admits herself, she catches herself saying it's a general intent crime. So she doesn't try and attack mens rea for that one. She says it's circumstantial evidence. So she goes after, did the prosecution meet their burden of proof beyond a reasonable doubt? She says she doesn't concede any count. She says, I'm not conceding anything. She said, I'm not conceding anything else other than I want to focus on the mens rea of these two counts that have a higher mens rea requirement, and she does focus on that. But she's very clear that she doesn't concede the other counts, and she also says she asks for an acquittal and says, in particular as to these two counts, but she doesn't concede guilt as to anything, and she certainly doesn't do what McCoy's counsel did of say he committed these crimes. I'm taking the burden off the prosecution. I mean, that's really what McCoy's about, is taking the burden off the prosecution. And that's not what happened here. She held the prosecutor to his burden. He made the fundamental objective choice. I want to hold the prosecutor to their burden. I want to seek an acquittal at trial. And his attorney assisted him in that endeavor. Their objectives were aligned. So this isn't McCoy error. There may be some other problem with her conduct of the trial, but it's not McCoy error. It's not that fundamental structural error.
Thank you, counsel.
Thank you.
Thank you, Your Honors. To this idea that it's the same objective being an acquittal, that's precisely the argument that Reed and McCoy reject. I think under the state's definition, neither Reed or McCoy would have gotten relief because in those cases, they're only conceding the actus reus. So in Judge Owen's example, that's McCoy. That's I want to avoid the stigma that comes with saying I killed my family. So under the state's definition, I think Reed and McCoy would have had to have come out differently. As far as the concessions, I think the state's problem is that the argument is just too technical. Reed looks at what was tantamount to a concession of guilt. Christian looks to what the jury would have understood counsel to be doing. McCoy suggests the same thing with the mental state quotes. And I think even the jury grappled with this because they send the question back about self-defense going, I think the logical conclusion being, well, this happened. I have counsel admitting to all this stuff, right? What do we do with this? I think the jury struggled with it. I believe it was Judge Wardlaw's question about arguing the voluntary intoxication as to the count 4, the negligent discharge. Below at 4 ER 671, the state concedes that, Sperber, quote, argued voluntary intoxication solely as to the criminal threats count and the negligent discharge count. So I think they previously read it the same way that I read it, and I think that's correct. Even the concession that the state was mentioning, the quote that I'm not conceding anything, the quote is, I'm not conceding anything else, after she acknowledges that the threats and the negligent discharge had just happened. The normal sort of construction of statutory interpretation, that would mean you conceded those things explicitly, at least. And just finally to this idea that this is an IAC issue, it's not. It's about the fundamental disagreement. It's not about strategy, right? Reed and McCoy's defenses were absurd defenses. Reed was saying he was demonically possessed. Mr. McCoy was saying there was this wild FBI conspiracy theory. The point is that it doesn't matter what the defense was. I mean, Mr. Mason's defense, I think, was a perfectly good one, but it really doesn't matter what it is. The problem is that fundamental disagreement. And if the court has no other questions.
Okay, no, thank you.
Thank you, Your Honors.
Mason versus McComber will be submitted, and I am not going to pronounce this correctly.
This records conversations better than taking notes.
I was like typing. Hold on. Never mind. That's it for today. That's it for today, ladies and gentlemen. I don't know about that. I'm not a lawyer. Somebody's not that smart in the law. But I'm going to go ahead and call this one for today. Tomorrow is, let's see, the Monroe County Court, which I think is like a municipal court. But I'm going to go ahead and call this one for today, ladies and gentlemen. We had a good day today. So, ta-ta and ciao-ciao for now. I will see you guys on the next live stream. And don't forget, Lisa, you're an idiot. I noticed she took a bunch of those. She took a bunch of them out of the paywall thing. But that doesn't stop people from getting your content, stupid. If you went public with a live stream and people got that content from you, you can't take them to court and sue them for copyright infringement while it was under a paywall. Because it wasn't under a paywall when you actually went live. But good luck. I think it's gonna blow up in your damn face. I think it's gonna blow up in your damn face. But that's it for today, ladies and gentlemen. Again, ta-ta and ciao-ciao for now. I'll catch you guys on the next live stream. You all have a wonderful, wonderful evening. And if you are not subscribed to this channel and you like this content, please do me a favor and subscribe to this channel and help this channel grow. And don't forget, guys, you guys do not hit the like button on any of this stuff. That's why this channel doesn't go anywhere. So hit the like, you guys. That's it for today. I'll see you guys tomorrow. How do I do this?
Yeah, I'm so fresh like the morning. Mouth wide open like they yawning. Every time they see me, they in G-Shock. Homie, this is too far. Homie, I feel too alive. You can see me like Illuminati. You can see me like Illuminati. But I'm shining so bright, so bright. Don't come and try to share some of this light, no. Give me a beat and I control it like a maestro. Ladies on a mission, they be trying to get me wiped up. Shawty, wait a minute, can't tell if I like ya. Gotta make sure you know how to shake it like a bartender. Team with me and they all winners. And you know we ballin' all winter, all summer. Jewelry around my neck is lightning, but I'm all thunder. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it, yeah. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it. Bring a friend and come along. Don't be taking too long. The vibe's too strong. If you don't know how to move, then we moving on. Ain't no way rhythmic feet up in this place. If you can't catch the feeling, then get out the way. I've been reeling and fish from the lake. Like you said, I'm down to earth, but I'm really out of space. All these women aliens, super foreign, so exotic. Hop in the Mercedes Benz, and I got them crushing like ice pouring the bub. It's overflowing on us. You drop it, then pick it up. I think I'm falling in love, but shawty, this isn't what you probably thinking it was. It's a vibe out, cooling it for the weekend. It's us. You gon' find out once you come on and bring me that up. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it, yeah.